Idaho Matters podcast is brought to you by St. Luke's On Demand Virtual Care, which allows patients to see a provider from their home using a computer or smartphone with on demand care for common ailments such as a cough, sore throat, or a sinus issue. More information at stlukesonline.org. Idaho is a big state and it covers a lot of territory. Idaho Matters wants to take you to every corner of the Gem State by visiting all 44 counties. And we need your help to do that. Email us your story ideas at idahomatters@boisestate.edu for our new series we're calling Idaho 44. And be sure to join us each weekday at noon and 8 on Idaho Matters and travel the state with us. From the studios of Boise State Public Radio News, I'm Gemma Gaudette. This is Idaho Matters. A federal judge has blocked Idaho from enforcing new rules that would have limited access to HIV treatment based on immigration status. The case, Davis versus Adams, puts a hold on parts of House Bill 135, meaning qualified Idahoans can still get care through the Ryan White HIV/AIDS program, no matter their immigration status. Doctors and advocates are calling this a major win for public health and immigrant communities. So joining us now to talk more about this ruling is Paul Southwick. He is legal director with the ACLU of Idaho. Paul, thanks for making time for us.
Happy to be here. Thank you.
So, Paul, what was the legal basis for the judge's decision to block House Bill 135? I mean, what stood out most to the court?
I think the judge was really concerned about the harm that would befall immigrant Idahoans if they were to lose their access to life-saving HIV medication. And within the context of the legal claims that were put forward, the primary claim is that federal law governs in the realm of federal public benefits, and that treatment for HIV is a communicable disease, that federal money going to treat HIV is governed by federal law, which has an explicit exemption with respect to immigration status. So this kind of funding is available to all people, regardless of immigration status.
So can you explain how this law, if it had been enforced, would have impacted patients as well as healthcare providers here in Idaho?
Well, healthcare providers were very concerned, as you can imagine, as many of their patients have a variety of immigration statuses. Some folks are fully undocumented. Some folks are recipients of DACA or have an asylum application pending. And the state law is very unclear about what lawful status means. And so what immigration status is required in order to receive public benefits, including access to HIV medication. And so providers were very scared for a lot of their patients. And the patients were extremely worried that they would lose this access to life-saving medication. And so for healthcare providers who are in the field of HIV, this Ryan White funding, the federal program where this funding comes from, it's called a payer of last resort. It means people who are receiving funding through this program, they have no other way to pay for their medication. They can't get it through through an employer-based health insurance program. They can't get it through the marketplace. They can't get it through Medicaid. There's no other way. And so these providers were going to see patients losing access to this medication, and they would then slowly, their health would slowly deteriorate, and ultimately HIV, if left untreated, is fatal.
You know, some might argue, Paul, this is about verifying eligibility for public programs. How would you respond to that from a legal standpoint?
So the Constitution has a clause called the Supremacy Clause. And the Supremacy Clause means that federal law is the supreme law of the land. And when federal law regulates in an area in which it has the power to do so, for example, with federal public benefits and federal money, then states have to follow the federal rules and regulations. And so the federal government made a decision when it enacted this statute, which is called per wara. We refer to that statute throughout our case, it's the Personal Responsibility and Work Opportunity Reconciliation Act of 1996. In that statute, Congress specifically exempted treatment and testing for communicable diseases from any immigration status requirement. And this is really important because HIV is a communicable disease, does not differentiate based on immigration status. It also doesn't differentiate based on a state's borders. It is a national public health concern that must be governed by federal law. And so that was the primary argument that we made to the court and that the court ultimately adopted, is that this Ryan White treatment is a federal public benefit from federal funding, and the federal government has decided it needs to be made available to everyone to protect all of us.
So, based on what you just said, then, I'm curious as to why it's unconstitutional, in your view, that we have this bill that tried to tie immigration status to access to programs like the Ryan White HIV/AIDS program. I mean, I'm assuming it goes down to what you said just a moment ago, which is, we're talking about a communicable disease, and you're right, it doesn't matter if you're an immigrant or not.
Absolutely. And the way that federal public benefits are governed is that certain federal public benefits are not available to people who are not citizens or have some other recognized immigration status. For example, people without lawful status are ineligible for Medicaid or SNAP benefits. There's a variety of federal programs and state and local programs that people do not have access to. But when we're in the world of communicable diseases and public health, that is where the federal law has decided to make a
Mm.
distinction. And it's a really important one. And so when it comes to the constitutional claims, it is about supremacy clause. It is about federal law being the law of the land. But there's also due process concerns. So the right to due process, particularly procedural due process. So when folks have been accessing this medication and relying on it as a life-saving treatment, they have a due process right to continue with it, meaning that the government cannot take it away without some kind of procedural safeguard, some kind of period of notice or other mechanism so that people have advanced warning of it being taken away and the process by which they could appeal the denial. And here, IDHW merely announced a policy with very little warning, very little notice to people.
Hmm.
And so there are due process concerns there, as well as equal protection, because the government cannot discriminate on the basis of alienage or immigration status without a reasonable justification for doing so. And here in the world of communicable diseases, there really truly is no reasonable justification for denying this medication.
So I want to go back to something you mentioned, which is this distinction between something in regards to public health and a disease like HIV/AIDS, which is a communicable disease, as we have noted, versus something like not having access to Medicaid or SNAP if you are not a whether you're a legal citizen, if you're not legally in the country, right? Um, how important is it that just the average person understands that distinction? Because anything that is a communicable disease, whether it's HIV, whether it's measles, right, whether it's chickenpox, um, it spreads. And again, it doesn't matter what your status is as a citizen or non-citizen.
Absolutely. And that's why our primary plaintiff, who is a doctor and an HIV clinician, she sees folks every day who rely on this medication in order to maintain their health and their lives. And she's very clear that because of where we are now with research and science, um, HIV is a fully treatable disease. And when someone is on treatment, they can no longer transmit that disease to anyone. And so making sure that people have access to HIV medication is, extremely important for them and their families, but it also protects everyone in the state because it doesn't matter what your immigration status is. Communicable disease can be communicated to you unless it is treated. And so that's why it's essential and
Mm.
really important for medical providers and people in public health because they know that HIV can be effectively treated and become untransmittable as long as people are able to access medication.
Do you believe this ruling could set a precedent for other states that are trying to pass similar laws?
I think so. I think that in other states where we've already seen a similar law passed in the state of Louisiana, and by similar law, I'm not speaking directly to the Ryan White program, but a similar law like HB 135, which imposed immigration status verification requirements more broadly on public benefits. And we saw a similar law passed in the state of Louisiana, and there are other laws working their way up through legislatures in different parts of the country. And so this is the first case in which a judge has said no, has said to the state that you have gone too far and that you have crossed the line in terms of what is permissible or impermissible to deny to our resident immigrants in our state. And we think it will send a very clear message to other states that when you are thinking about the implementation of your own law, that you need to think differently about Ryan White funding. You need to think about differently about public health, and that such immigration verification requirements not only don't make sense from a public health standpoint, but are also unconstitutional and will not be tolerated by courts.
What message do you believe this ruling sends to immigrant communities across Idaho, but really beyond Idaho as well?
Our immigrant neighbors are under increasing attacks from all sides. And this law, HB 135, it was really designed to dehumanize immigrant neighbors, denying them access to basic necessities like medicine, food, and shelter. And it's part of a broader campaign, both in our state and elsewhere, to essentially forcibly displace immigrants in Idaho and in other states by making it so difficult to live here and to even have access to basic health care for pregnant people, for children, for people living with chronic diseases. The overall idea is to have these laws work together to forcibly displace our immigrant neighbors, which tears apart families and disrupts communities. And what we are trying to do in bringing this lawsuit is to send a message to our immigrant neighbors that you are not alone, that someone is fighting for your rights and fighting for your basic access to life-saving medical treatment. And I think that that sends a message to immigrant communities that will help them know that they belong and they deserve to be treated humanely within their own communities.
Paul, what are the next legal steps in this case? Because I'm assuming the state could appeal this injunction.
That's right. And so we filed our lawsuit at the very end of June and immediately received a temporary restraining order, which generally lasts for 14 days. So the court held a hearing on July 15th for our motion for a preliminary injunction, which is an order that would stop enforcement of the law for a much longer period of time. And on July 24th, the court granted our motion for preliminary injunction and essentially blocked the law for the length of the litigation. And so at this point, the state can consider whether or not to appeal that preliminary injunction. But as we move forward, that injunction will remain in place, and then the case can be litigated. There will be evidence that will be gathered and presented to the court until the court ultimately makes a final ruling on the merits. And it was a really significant victory for us, not only to get the preliminary injunction, but that the court granted class-wide relief. This was brought as a class action. And so court granted provisional class action, which means all people throughout the state are protected, not just the patient plaintiffs in our case.
My understanding is that House Bill 135 affects more than just HIV care. So are you planning to challenge other parts of the law?
Yes, 135 has devastating impacts beyond access to healthcare. For example, the WIC program, Women, uh, Infants, and Children, provides food assistance to low income Idahoans who are pregnant or who have recently given birth or who are young children. And the state of Idaho has decided that it is going to take that food assistance away from pregnant people or from women who have just given birth. That's going to have a really devastating impact on immigrant communities. We also recently learned that the Crime Victims Compensation Program in the state of Idaho is now going to require immigration status verification before you can get assistance as the victim of a crime. The the way that this law is being implemented is cruel, and the state has clearly gone too far. And so we are carefully examining as we learn about new programs that are being impacted by HB 135. We are carefully examining whether we can bring claims to move to add them to the case.
Paul, before I let you go, is there any one part of this law that you want the public to understand in regards to truly what's at stake here?
That's a really good question. I think what is most important to remember here is that immigrant residents in Idaho, they are part of our communities. Maybe not everyone knows someone who is undocumented, but folks who are undocumented, we can relate to them, their mothers, their fathers, their children. And I think that common values that unite us all as Idahoans are that we care for one another, that we believe everyone should be treated humanely. And HB 135 just runs counter to that by denying some of the most vulnerable people in our state access to basic things like food when they are hungry, medicine when they are sick, shelter when they have nowhere else to go. And so I think it's really important for Idahoans to let the state legislature, let their legislators know that they're not okay with these impacts. And hopefully we can see the Idaho Department of Health and Welfare and the legislature change course next legislative session so that we can restore some of these really basic necessities of life to folks in Idaho who really need the support.
Well, I want to thank you so much for taking time to speak with us. We've been talking with Paul Southwick. He is legal director at the ACLU of Idaho. We've been discussing the implications of a ruling by a federal judge in regards to immigration status and access to HIV treatment. I'm Gemma Gaudette, and this is Idaho Matters.